Hi, my name is Sharmin Anwar. I'm an attorney with Cobb Legal Aid, and I run the Lawyer in the Law Library program here in Cobb Superior Court. Today, I will be giving a presentation on employment discrimination. Just a little bit of background about Cobb Legal Aid. Cobb Legal Aid is a nonprofit law firm that provides free legal advice and or assistance to low-income individuals for many basic civil legal problems. And we prioritize issues of shelter and safety. We handle a variety of cases such as family law, housing, education, special education, and public benefits. And as the lawyer in the law library, I provide free 30-minute consultations to qualifying individuals on qualifying matters every Monday through Wednesday from 9 a.m. to 4 p.m. Consultations can be provided on a walk-in basis or can be scheduled through our online appointment system. When to call legal aid: if you are being evicted, if your landlord refuses to make repairs, if you're experiencing domestic violence, if your disabled child's educational needs are not being met, or your public benefits were terminated. Legal Aid does intake and screening by phone 9 a.m. to 12 p.m. Monday through Thursday, and you can reach us at 770-528-2565. You can also do an online intake for non-urgent issues. Just a disclaimer, the presentation that I will be giving today is based on general Georgia law. For a specific consultation or for specific advice, we advise you to talk to an attorney, or as I'd mentioned, you can see if you qualify for a consultation with me to discuss your specific issues. So as I said, today we will be talking about employment discrimination. What is employment discrimination? Well, it occurs when an employee is treated differently or less favorably due to a protected status, and there are several protected statuses. They include race, color, religion, sex, which now also includes pregnancy, gender identity, and sexual orientation. It's important to note that some of those were not previously included in the definition of sex. So employment discrimination also occurs if someone is treated differently or less favorably based off of their national origin, disability. It's important to note that not all disabilities are covered. It would be covered on a recognized disability under the ADA. Age is also one of the protected statuses, but not all age. It's age where if you're 40 or older. And genetic information is also a protected status. It's important to note that Georgia is an at-will state, which means that your employer can terminate you or take an adverse employment action against you for really any reason at all, no reason at all, so long as it's not unlawful. And that's the important distinction that needs to be made, which is when an employer acts unfair or when they act unlawfully. Sometimes an adverse employment action feels incredibly unlawful, but it may not be. It may just be an unfair action that was taken against an employee. So ultimately, in order to successfully show employment discrimination, the employee needs to show that it was actually unlawful and not just that it was unfair. It's also important to note that there are not many laws in Georgia that allow an employee a wrongful termination claim, but there are plenty of federal laws that prohibit discrimination in the workplace, and we will be talking about those. So there are several federal laws that come into play here, and I'm going to talk about the most common ones and kind of dive deeper into the ones that we see more regularly. So the first one is the Americans with Disabilities Act, which is also known as the ADA as amended. And this protects employees with disabilities. Importantly, as I'd mentioned before, it's not every disability out there. It's a recognized disability. And the ADA requires employers to provide reasonable accommodations to employees with disabilities unless it would cause an undue hardship. So this is also important to kind of pay close attention to. It's not that the employer is required to give the reasonable accommodation you're asking for under any circumstance. It's really about whether that accommodation the employee is seeking is reasonable and whether it would present an undue burden. So it's really about the employer engaging with the employee to see whether that accommodation is feasible. And when we talk about accommodations, there are several examples that, maybe an employee is seeking. It could be an accommodation with equipment. So for example, providing or modifying equipment or devices such as screen reader software, video phones or tape recorders, or ergonomic chairs and desks to accommodate a disability. Another accommodation that we look at is work environment, where an employee may ask the employer to make the workplace accessible, such as installing a ramp or modifying a restroom. Work schedule is also a common reasonable accommodation that some employees seek, which could be providing flexible work schedules, such as adjusting work schedules to accommodate for doctor's appointments, frequent doctor's appointments, and things like that. Job duties, this is also something that people seek a reasonable accommodation, or if that's the reasonable accommodation they're seeking, which could just be restructuring the job, such as changing the job duties itself to accommodate that disability. The next federal law that we talk about, this is probably the most common one we hear, which is Title VII of the Civil Rights Act. This protects employees, as I'd mentioned, from discrimination based off of race, color, national origin, those protected statuses we talked about before. And it is so important, again, to note that it has to be discrimination based on. Sometimes people will feel that they're discriminated and they're not sure why. So in order to really pursue a discrimination claim, you have to dig deeper and ask yourself, what was the discrimination based off of? And was it based off of a protected status? Sometimes an employer may treat an employee less favorably, and it may not be because of a protected status. And that's sometimes where we come into a situation where an employee feels that they were discriminated, but what really happened was unfair treatment that doesn't really rise to the level of unlawful behavior. The next law is Section 1981, which protects employees from discrimination based on race. So just like Title VII, which does not allow discrimination based on race, Section 1981 also prohibits that. The difference is that Section 1981 has uncapped damages, meaning they don't cap the amount really that you're seeking compensation for the discrimination you faced. The next one is the Age Discrimination in Employment Act, which protects employees from discrimination based on age. Of course, it has to be over 40. The Genetic Information Non-Discrimination Act. This protects employees from discrimination based on genetic information. The Uniform Services Employment and Reemployment Rights Act, which protects employees from discrimination based on military service. The next big one that we do see often also is the Family Medical Leave Act, which is known as FMLA for short. And this protects employees from discrimination based on taking protected leave. And this provides certain employees up to 12 weeks of unpaid leave, and it's job protected leave per year. And it also provides health benefits during that leave. So it's important to break this down. It's one, you have to be eligible, so you have to be protected, someone who qualifies for FMLA. Two, it's just up to 12 weeks. It's not more than that. And it is unpaid leave. So some people will choose to take all 12 weeks at once, depending on their needs. This is something we see often in situations of maternity leave. Some people will take FMLA kind of in chunks. So if their need is just for a few weeks, then they'll take maybe 4 weeks, and then they still have 8 weeks of FMLA leave remaining. So there are a number of reasons why someone would take FMLA leave. It could be for the birth and care of a newborn child. It could be for placement with the employee of a child for adoption or foster care. It could also be to care for an immediate family member who has a serious health condition. So the employee could seek their FMLA leave not for their own serious health condition, but if a close family, an immediate family member, meaning a spouse, a child or a parent has a serious health condition and the employee would like to use their leave to be with that immediate family member and to care for them. FMLA can also be taken, of course, when that employee has their own serious health condition. And what it does is it protects your job during that time that you're taking leave, whether it be 4 weeks or the full 12 weeks. It protects it so that when you do return to work after that FMLA leave, you are restored to that same or similar position. The next federal law is the Occupational Safety and Health Act, which is known as OSHA for short. And this protects employees from discrimination if they make a complaint regarding workplace safety. We often see the anti-retaliation aspect with OSHA, which has a very short time in which an employee may make a complaint with the Department of Labor, which is only 30 days. The next one that we see commonly is the Fair Labor Standards Act, which is known as the FLSA, and this protects employees from discrimination if they make a complaint about the employer failing to properly pay them under this act. And it is important, you'll often hear when you're talking about FLSA, exempt versus non-exempt employees, because the rules are a little bit different if you are exempt or non-exempt. It is also important to note that the laws that we just discussed do have anti-retaliation clauses, which punish an employer for treating an employee differently or poorly because they made a complaint about discrimination based off of one of those laws we talked about. Interestingly enough, people tend to be a bit more successful on the anti-retaliation aspect of it than the actual underlying discrimination claim. So we've talked about what employment discrimination is. What I want to talk about now is who is in charge of enforcing, or who do you even report employment discrimination to? And there is a federal agency called the Equal Employment Opportunity Commission. It is known as EEOC for short. This is a federal agency which enforces the federal laws that protect you from employment discrimination. And their mission is to promote equal opportunity in employment and to remedy unlawful discrimination. And they enforce federal laws that apply to all types of actions like hiring, firing, promotions, harassment, training, wages, and benefits. And we'll talk a little bit more about what types of practices are considered discriminatory. Not everyone is, and not every situation is protected. So let's talk a little bit about what that is. So if, for example, there's unfair treatment, if there's harassment, if there's denial of a reasonable workplace change that you need because of your religious beliefs or disability, we talked about what some of those workplace changes are in terms of disability accommodation. It's also inappropriate if there are improper questions about or disclosure of your genetic information or medical information. Keep in mind this gets a little tricky when you are asking for a disability accommodation, because at that point you are bringing up your own health and disability. So it does make sense for your employer to ask further about your health condition with whatever is reasonable within those bounds to be able to make that reasonable accommodation. Retaliation, as we talked about, because you complained about job discrimination or assisted a job discrimination proceeding, such as an investigation or a lawsuit. So there could be a situation where an employee may not be the one who experienced the underlying discrimination that is being investigated, but they witnessed it or they testified about it or they wrote an affidavit about it and they experienced some type of retaliation. Not everyone is protected under these federal laws, and the EEOC will not investigate everybody's case. So you have to essentially be an employee, a job applicant, which is interesting. Not everyone realizes that the EEOC and some of these federal laws apply to job applicants. Usually you think about in the sense of, well, employment means I'm employed, but actually job applicants, if you're applying for a job and you feel that you've been discriminated against, the EEOC would possibly investigate your case too. because let's say you were not hired for a job based off of your gender, that would apply to a job applicant. It also applies to union members and applicants for membership in a union. So just like not every individual is covered by the EEOC and these federal laws, not all employers are also covered. So employers that are covered are those that it covers most employers with at least 15 employees, with some exceptions. For the age discrimination, there needs to be at least 20 or more employees. These laws that we talked about, they apply to private employers, state and local governments, education institutions, employment agencies, labor organizations, and joint labor management committees. So even if you may be an employee, you may be a job applicant, so even if you as an individual are classified as someone who is protected, if the laws don't apply to the employer that you are actually applying to have a job with or that you are employed with, then unfortunately the law wouldn't be able to serve you in that situation. So if we're talking about a small startup of just a handful of people, if they're not meeting the threshold requirement of employees, then unfortunately there may not be much recourse for some employment discrimination. Let's talk a little bit more about the practices that can be discriminatory. So if some of these things are happening, these are the things to look out at work, and that may ultimately be discriminatory. So the most common one is discharge, such as firing or layoff. That kind of practice could be discriminatory. Harassment, which includes both verbal and or physical conduct. And harassment is a little bit harder, right? Because it's kind of something that happens maybe over the course of several weeks or months. Sometimes it could be some substantial conduct that happens once or twice, but it is substantial enough. But harassment is also included. As I'd mentioned, hiring is also a practice that could be discriminatory. Also promotion. So if someone doesn't get a promotion, that could also be discriminatory. You may see that in a situation where there are two employees of the same rank with essentially the same resume and experience, but one person gets it over the other, and maybe the distinguishing factor is their gender or maybe their race. And there's other elements present that would suggest that the employer was motivated by the individual's race or gender when they made that promotion or hiring decision. There's also assignment. So for example, the assignments you receive, if there's some disparity in that could also be discriminatory. Failure to provide a reasonable accommodation, again for a disability or a sincerely held religious belief, observance, or practice. Benefits, if they're being given in a discriminatory way, that could also be a violation. Job training, if it's only available to some people and not others, and there's some underlying motivation based off of a protected status, that could also be discriminatory. Referrals, people don't realize this, but even the process of referrals, if the way that's being done is discriminatory, then you could be protected. Obtaining or disclosing genetic information of employees, or requesting or disclosing medical information of employees. Again, that one, the last one, is a little bit tricky when we are talking about disability discrimination or disability accommodation, because at that point you're bringing up your health to get some kind of accommodation. So it only makes sense for the employer to request maybe more information to see if that accommodation is feasible. So we've talked about who's covered, what kind of employers are covered, what types of practices may be considered discriminatory. So when you're going through this analysis and thinking, okay, I'm an employee or I'm someone who is likely covered and my employer is covered, and I believe I experienced some type of discriminatory practice, what do I do next? Well, the next step is to file a charge of discrimination with the Equal Employment Opportunity Commission, and I'm going to be saying EEOC just for short. So this is a really critical step. You have to file this charge, and this charge essentially is a complaint that you're filing with the federal agency, notifying them that you have experienced some form of discrimination. And this charge essentially asks for information about yourself, information about your employment. So where do you work, or where did you work that you experienced this adverse employment action? What was your position? Who's your employer? When were you hired, or when were you fired, or when did you experience that adverse employment action? So it gathers all that information. There are a few different ways to file a charge of discrimination. You can do it online on the EEOC's public portal. You can also submit an inquiry and they can interview you through their portal. You could do it in person at your local EEOC office. You can't file a charge over the phone, but you can begin the process by calling and speaking to a rep who would get some basic information to determine if your situation is covered by the laws that the EEOC enforces. And then they'll explain to you how to file a charge. So I guess if in a situation you're not even sure whether your employer is covered, or you're not sure if this is the appropriate avenue for you, you could call and just get some information, and a representative would sort of evaluate it for you. You could also do it by mail. And if you do it by mail, you would have to include certain information, such as your name, address, email, and telephone number. The name, address, email, and telephone number of the employer that you're filing the charge against, the number of employees employed there, if you know. If you don't know, then obviously you can leave that blank. You would need to include a short description of actions you believe were discriminatory. So, for example, if you were fired, you would say, I was let go on X date. I think it was because of my religion, and you would just give a little summary of why you think that. And then you'd also include when the discriminatory action took place. We'll talk about why that's important, why the date is important. And then again, why you believe you were discriminated, and then your signature. And it is important to try to do that more quickly if you are doing it by mail, just because things can get lost in the mail. It can take a little bit of time, and we'll talk about why timeliness is important. So the reason why timeliness is important, because there is a time limit for filing your charge. So there's, for filing that complaint. So the deadline to file a charge with the EEOC in Georgia is 180 calendar days from the date of the alleged violation. So if you are outside of that 180 days, you are barred from filing that complaint with the EEOC. And if you don't have any similar state laws to sue under, then you're unfortunately out of luck, and you really can't pursue that employment discrimination claim. So that's why it's very, very important to be mindful of this 180-day deadline and to stay within it. And that's why I said if you're going to do it by mail, it is so important to do it sooner rather than later, because you want to make sure that it's received in a timely manner. It is important to note that the deadline can vary state to state, depending if you're a deferral state versus a non-deferral state. So there are some states that have their own local agency and local state laws that prohibit this behavior. And if that's the case, the deadline is 300 days from the date of the violation. If you're a state like Georgia that doesn't have that, then it's 180 days. And it's really important to look into that if you are considering filing a complaint, because there are people. I had a situation where someone came from a state that had the 300-day deadline. When they are in Georgia, they assumed that it would be 300 days, but it's not. So it's always important to look up what that deadline is. So as I'd mentioned, if an employee misses that deadline to file an EEOC charge, the law generally will not allow a late filing. It'll typically just bar that employee from pursuing that claim. Now, something that has been a bit confusing for employees sometimes is, when is that date of the alleged violation? There are certain practices that, discriminatory practices that have a very clear date. For example, termination, right? Usually when someone is terminated, it's pretty clear that what that date is. Usually it's supported by maybe a letter or maybe by a separation notice that will clearly state when you were let go. But what about for situations of harassment, or what about for situations of that they're just maybe not as clear, maybe the promotion or this or that, things that maybe the dates may not be as clear on. So the 11th Circuit Court of Appeals has stated that the time period, that 180-day time period, doesn't start to run until the worker receives unequivocal notice of an adverse employment action. So the employee would have to unequivocally know and be aware of the fact that this adverse employment action has happened, so that they, were not hired or were not promoted or didn't receive referrals or didn't get an accommodation. So if it's not super clear, then there may be an argument that that 180 days has not started to run. So once you file the EEOC charge, what happens after that? So the EEOC will give you a charge number, and this is kind of like your case ID, what is your claim is associated with. And then usually within 10 days, the EEOC will send a notice of the copy of the charge to the employer. Now, interestingly enough, this stumps a lot of people, or they're confused, or it almost worries them that, oh, I didn't realize that my employer would know that I filed a charge of discrimination. But in order to do a proper investigation and to look into a claim of discrimination, this federal agency has to notify the employer. They have to be able to understand fully what happened. So sometimes people don't realize that, but yes, your employer will be notified of this charge of discrimination. And that's something that, for whatever reason, when people are filing a charge while still employed, because maybe it was the adverse employment action was failure to promote or failure to accommodate, that's something people don't realize. Well, I'm still working there. How will this affect things like that? Once your employer is notified, there's a few different things that can happen. There's going to be an investigation where witness statements can be taken and documentation can be gathered to figure out what's going on. Your employer and you could also be asked to engage in a mediation program. This is a program that's put on by the EEOC, by an EEOC mediator. And what happens is both parties come to the room with a mediator. The mediator does a quick intro, explains essentially the rules of mediation, and then the employer and employee are separated. They're in separate rooms, and the mediator goes back and forth and tries to resolve the issue so that this doesn't have to go further and essentially settle the issue. Sometimes these mediations can be very helpful and can resolve in some kind of settlement in which you do agree to maybe settling the case, and then afterwards you sign a settlement agreement. So they can be helpful at times. The EEOC could also dismiss your claim if your charge was not filed in time or if the EEOC doesn't have jurisdiction over it. Importantly, if your charge has been sitting with the EEOC for 90 days, then you can request your notice of right to sue. Now, the notice of right to sue is very important. This is the document that allows you to sue in federal court. So, for example, if you have faced some type of discrimination, you cannot straight away go to federal court and file your discrimination claim. You have to have that little ticket, the notice of right to sue, from the EEOC to then go to federal court and file your claim. So if your case is sort of just sitting there, there's not much movement, nothing's happening, you haven't gotten your notice of right to sue, you can request it from the EEOC even before the EEOC has closed out your case. Once you get that notice of right to sue, you only have 90 days to file in federal court. So these deadlines are very important, and I believe you can request your notice of right to sue if it's been sitting for 90 days, but for sure you only have 90 days once you've gotten your notice of right to sue to file in federal court. Once you file in federal court, then you can move forward in that process. Well, what happens if the EEOC does an investigation and finds cause, meaning they find that they believe that there may be some type of discrimination going on? A lot of the times the EEOC will take that case and say, you know what, we've investigated it, we believe there's some discrimination here, we have a team of attorneys and we would like to represent in this situation. So that's a possibility as well. So let's say you get your notice of right to sue, so you can pursue this claim in court, and you would follow the steps, from there essentially. But it is important to talk a little bit about the reality of an employment discrimination case in federal court. So majority of these cases are actually dismissed on summary judgment and don't see a day in court really, or don't go to trial. And summary judgment essentially is where the employer often files this motion and says, you know what, all the facts essentially, there's no disputable facts, they point in our favor, the judge can really only find for us, the employer. There's no discrimination going on here. So a lot of employment discrimination cases actually do get dismissed. And these cases can often take a long time, and sometimes it's more beneficial for an employee to just go ahead and settle because they may need that they may need that money essentially since they're out of a job or whatever it may be. It sometimes is just more beneficial for them to go ahead and settle, take the money, rather than go through possibly years of litigation. And the proof process of employment discrimination cases can be pretty difficult because you have to show that you face that adverse employment action in violation of a federal law, right? So for example, if you were let go, you were fired, and you think it's because of your race, well, the employer may have a bunch of evidence to show, well, actually, no, you consistently missed work, or you didn't perform well, or you were on a performance improvement plan. And that's why proof can be a little bit tough, because there could be other reasons, well-documented reasons as to why you were let go and why the reason of a protected status is really not plausible. So the key takeaways then is, well, what can I do, right? Well, you should document incidents. If things are happening, it's important to document it, whether it's writing it down, sharing it with HR, talking to HR, making these complaints. More importantly, written complaints, because verbal complaints are far harder to prove and trace. Written complaints with a date, specificity are much better. It's important to make members of management aware of this. And the reason being because for some of these claims, the employer could say, well, how could we have known about the discrimination? How could we have known about the harassment if these complaints were never made to the right people? So that's why you want to make sure you let the members of management know when something like this is happening. But in general, it's important to know what your rights are. It's important to know what laws exist, what timelines exist, and deadlines exist. And I hope that this presentation was helpful for you. As a reminder, you can call us if you believe you have any legal concerns, whether it be about employment discrimination or about any other of the civil legal matters I mentioned at the beginning. You can call us, you could do an online intake, or alternatively, you could come to the law library and possibly receive a free consultation if you qualify. Thank you so much.